Okay, so now we go through Taylor Swift's response to the motion for a preliminary injunction, which Marine Flag is basically trying to prevent her from continuing to use the life of a showgirl as a trademark whilst this this complaint is pending. So it's a temporary thing, and then she will seek a permanent injunction as part of the resolution of her complaint. Okay, so let's see. I have done a video on the on Marine Flag's motion for the preliminary injunction. So if you haven't watched that, it's a really good motion. I really like how her attorney drafts the legal filings. I'm interested to see this one though. I have been told it's aggressive, so let's go. This motion, just like Marine Flag's lawsuit, should never have been filed. It is simply Miss Flag's latest attempt to use Taylor Swift's name and intellectual property to prop up her brand, and it fails every step of the preliminary injunction inquiry. I mean, is she trying to use Taylor Swift's intellectual property to prop up her brand, or is Taylor Swift trying to use her intellectual property to market? Putting aside the fact that the marks at issue are not confusingly similar, that's just ridiculous. Marine Flag has presented so much evidence, including from the Federal Office of Trademarks. Oh, I'm gonna get annoyed through this. Putting aside the fact that the marks at issue are not confusingly similar, it is beyond the bounds of reason that consumers would believe that plaintiff's mark, Confessions of a Showgirl, or plaintiff's cabaret shows are in any way affiliated with Taylor Swift or her album, The Life of a Showgirl. I mean, I got confused in the last video, and I was going to refer to Life of a Showgirl as Confessions of a Showgirl. Even I got confused, and I'm sitting here reading a document telling me why they're confusing. Far from showing any concern about the album after its announcement, Miss Flag spent several months centering her brand on the Life of a Showgirl's name, artwork, music, and lyrics to promote her little-known cabaret show. In fact, a mere 4 days after Miss Swift announced her album title and artwork, in August 2025, Miss Flag announced a brand new podcast mimicking Miss Swift's album artwork, logo, title, and taglines. Then plaintiff flooded her Instagram and TikTok pages with 40-plus advertisements for her brand using Miss Swift's music, trademarks, and other intellectual property without permission. Each of these advertisements constitutes actionable infringement, and TASRM will be pursuing appropriate remedies for that intentional commercial misuse. Okay. However, when plaintiff attempts to exploit Miss Swift's intellectual property failed to garner the desired attention, likely because, despite Miss Flag's best efforts, consumers were not confused into believing these two brands were even remotely connected, she concocted a meritless lawsuit and brought this motion for a preliminary injunction. Motion fails at every turn. First, plaintiff cannot show likelihood of success on her trademark claims. As a threshold matter, the album title and its associated promotional goods are expressive works protected by the First Amendment, rendering the traditional likelihood of confusion test inapplicable. However, even if the Lanham Act likelihood of confusion test did apply, and it does not, each of the factors to be considered weigh heavily in defendant's favour and against injunctive relief. Second, plaintiff has not and cannot identify any irreparable harm. From the moment the album was announced, plaintiff embraced and sought to associate herself with it and Miss Swift. Plaintiff cannot now claim confusion or harm over an association she tried to manufacture. Not once did plaintiff take any action to contest the growth of the album and its related goodwill. Instead, plaintiff waited for 8 months, all the while using album materials in her advertising before claiming the need immediate relief. The fact that Miss Flagg did not get the marketing boost she wanted from exploiting Miss Swift's album is not irreparable harm, and to the extent any harm is cognizable here, it is not. Money damages would readily compensate plaintiff. Now, I disagree with that, because Marine Flag made the very good point that once the brand has kind of been taken over entirely, you can't get that back. Third, the balance of hardships weigh heavily in defendant's favour. Given the breadth of the injunction sought, if it were to issue, the album would be pulled, merch destroyed, and access. Well, it doesn't have to be destroyed, it's just pending. And access to heavily sought after goods curtailed. Such relief would result in a ban on Miss Swift's expressive work and tens of millions of dollars in lost revenue to the defendant entities. Fourth, the public would also be harmed as streaming platforms and business partners would have to remove products and myriad fans, and consumers would no longer be able to access music and goods that are in high demand. The motion should be denied. Okay, so facts relevant to denial of the motion. Plaintiff's purported goods and services. Plaintiff, Marine Flag, professionally known as Marine Wade, is a former Las Vegas showgirl. She owns U.S. trademark registration for Confessions of a Showgirl, with respect to blogs, theatrical productions, and television programs in Class 41. She claims to use the mark in a column in Las Vegas Weekly, a live theatrical production, a book, a podcast, and video content distributed through television, YouTube, and social media. The reality is very different. The last blog from her website is dated March 10th, 2021, over 5 years ago. Plaintiff's book is out of stock, referencing only a pre-order with no stated release date, and her ebook is unavailable for purchase. Okay. I'm just going to pop over to that. Let's have a look. So, I mean, I do feel that's a slight misrepresentation. Yes, the previous edition is sold out, but as is quite a common thing with books, there are periodically new editions. Editions are updated and then re-released, and it is inviting you to pre-order a new forthcoming edition. Therefore, there is one on the way, but there was a previous edition. It's just that edition has sold out. He's implying that she doesn't sell a book, or she hasn't done for a long time. This doesn't tell me that. This tells me that, they've now sold what was of the former edition, and there is a new edition, which is, you can now pre-order it, which suggests its release is imminent. Okay. Defendants have found no use of plaintiff's mark in connection with a podcast outside of one podcast teaser created days after the announcement of Miss Swift's album, copying its branding and using the album title to summarize the podcast. To date, no episodes of the podcast have been released, and while she may have originally produced printed columns under her mark, these were abandoned along the way, as evidenced by the deletion of these goods from her trademark registration. Plaintiff also claims her mark covers live stage performances that are limited to theatrical productions, namely her cabaret shows. She performs, if at all, in small intimate venues such as a 55-plus active community, 55-plus golf resort, 90-seat cabaret-style venue that offers dinner, hotel, and private supper club. Her website lists no upcoming performances, and plaintiff does not identify any in her motion. When using and promoting her mark, plaintiff highlights confessions, depicting it larger above other text and in a color setting it apart. It appears with a bright yellow and red or bright yellow and pink color scheme, usually together with Miss Flagg's image. Taylor Swift and the Life of a Showgirl. Taylor Swift is a singer-songwriter and global icon. In the wake of the groundbreaking stadium tour Taylor Swift The Eras Tour on August 13th, 2025, Miss Swift announced her 12th studio album titled The Life of a Showgirl. The title has clear artistic meaning as the album is about what was going on behind the scenes in Miss Swift's inner life during the Eras Tour, which was so exuberant and eclectic and vibrant. It reflects upon the complexities, good and bad, of the life of a performer, a showgirl. The album was released on October 3rd, 2025, and was immediately successful. In its first week in the US alone, it sold over 4 million units and was streamed nearly 681 million times, the largest first week of sales in modern music history. The album was the highest selling album of 2025 with over 6 million units sold that year. The album includes as its 12th track the song titled The Life of a Showgirl. To date, no songs from the album have been performed live. As shown on the album cover, defendants often depict the life of a showgirl in a uniform-sized font in a glittery orange color with the life of a and showgirl all distributed on separate lines, complemented by accent use of a mint green color. And defendants' use of the life of a showgirl is typically accompanied by the unmistakable likeness of Miss Swift. On August 11th, 2025, defendant TAS Rights Management filed an intent to use trademark application with the USPTO for the life of a showgirl. Because the application is based on an intent to use rather than a prior use, the USPTO could not evaluate any specimens of use showing how the life of a showgirl actually appears to consumers. On November 5th, 2025, the USPTO issued a non-final office action for the application, again solely based on a review of the words themselves, without any evaluation of how the words are actually used by defendants or viewed by consumers. A non-final office action is exactly what it sounds like, not final and not uncommon. It allows the applicant to submit materials and context to cure any perceived defects, often resulting in a registration issuing. Plaintiff tries to associate herself with Miss Swift and the album. Since the album announcement, Plaintiff has reframed her brand around the album, flooding her social media accounts with posts, attempting to align herself with Miss Swift and the album. Prior to the album announcement, Plaintiff had never used the life of a showgirl in her social media promotion. Following the announcement, Plaintiff used the phrase or posted generally about Miss Swift or the album over 40 times on her branded Instagram and TikTok accounts. On TikTok, 34 of the 38 total posts on Plaintiff's account are celebrating Miss Swift and exploiting album IP. In fact, Miss Flagg's brand bio reads, "The life of a showgirl, baby that's TikTok," identifying her brand using the album title and a version of Miss Swift's album tagline. Right. Okay. And let's go and have a look at that. There. I mean, she does say that. I'm going to just actually check something out a minute. Okay. Okay, so I have to concede that that's not a good look. It's not. When you're saying this is harming me and there's, people are getting confused, it kind of You don't look like you've got too much of a problem in those posts. I'm going to keep an open mind. I'm not sitting on one side of the fence or the other. Let's continue with this, though. These posts also consistently use hashtags such as the hashtag life of a showgirl, hashtag TS12, hashtag Taylor Swift, hashtag Swifties, hashtag Taylor Nation, hashtag TLOAS, and hashtag Dear Taylor, encouraging Miss Swift's fandom to find plaintiff's posts when searching for album-related content. 2. Song titles from the album. 3. Captions such as In My Showgirl Era, referencing the Eras tour, and the well-known use of the word era to describe Miss Swift's albums. And 4. Audio clips from various songs by Miss Swift. Some posts contain all of the above. In one post, plaintiff used an album cover logo, audio from the album title track, hashtags including hashtag life of a showgirl, hashtag Swifties, hashtag TS12, and hashtag Taylor Nation, and discussed an official album release event. In addition to attempting to confuse consumers, plaintiff's commercial use of Miss Swift's art constitutes clear infringement under federal law. Okay. Yeah, that could be problematic. It is. He's making a good case. Again, this is not as simple as, oh yeah, no, everything Douglas Baldridge is saying here, assuming it's Douglas Baldridge. Everything he's saying here is true, but when he says, oh look, actually, when the album come out, you actually try to kind of piggyback off it and ride the coattails, he is showing evidence which supports the possibility of that. But we're still a long way away from sort of determining who's actually usurped what. Furthermore, 4 days after the album announcement, plaintiff released a podcast teaser dramatically rebranding her materials to mimic Miss Swift's, describing her podcast as The Life of a Showgirl. Miss Flagg suddenly shifted her branding from pinks and yellows with bolded sans serif fonts to a mint backdrop with an elongated thin font backed by cutout shapes, stacking the text to create an overall blocked shape with her name slightly set off in a smaller font, clearly evoking the imagery of the album and its related promotional materials. See, in the last video, right, because Ashley was like, oh, look, she's copied all of the colouring and everything of Taylor Swift, but if this has come post announcement of Taylor Swift's album and that cover has already been put out there, then yes, she has changed her brand to mimic Taylor Swift. Although I will say the colours here in this album are actually very similar anyway, because look, the mint green is in this middle one, which was her historical branding. The mint green, the pink, the yellow with the pink text. That was already there. All they've done is change the background from yellow to pink to green, to the mint green. That's it. I wouldn't say that she's dramatically changed anything because all the elements are already there. If she had changed the font color, to orange, I might be inclined to agree. But I don't think there's much there at all. And she already did have that mint green in. Sorry, she did. I'm not so sold on this one actually. Now, initially I'm like, oh god, yeah, that looks quite similar. No, I prefer hers. I do actually prefer hers. But the mint green is the same color that she already has. All the elements in this new rebranded kind of cover here, I think, they are in the middle one too. It's just been reorganized. So prior to August 17th, 2025, plaintiff did not have a podcast and defendants have found no mention of her intention to start one. Defendants have also found zero evidence of plaintiff's use of this color scheme and logo visual prior to the album announcement. Oh, dude, seriously, go back and have another look. Plaintiff lies in wait for 8 months. Plaintiff admits she knew about the album in August 2025 and consulted with counsel at that time, but did nothing to contest the album's release and/or approach defendants regarding her purported concerns. Notwithstanding her own admission that she was aware of the album from day one, as well as the myriad social media uses shown in Exhibits 27 to 72, plaintiff did nothing and said nothing about any alleged harm. Instead, she did her best to shout from the proverbial rooftops to forge a connection to the album, attempting to get the attention of Miss Swift's fandom for her own gain. Meanwhile, in 2025 alone, over 6 million The Life of a Showgirl albums were sold and 681 million streams occurred. Now, 8 months later, having first voluntarily availed herself of the album's release and its related goodwill, plaintiff seeks to preclude defendants essentially from any use of the created expression, the life of a showgirl. Standard. A preliminary injunction is an extraordinary remedy, never awarded as of right. For preliminary injunctive relief, plaintiff must make a clear showing that 1. She is likely to succeed on the merits. 2. She is likely to suffer irreparable harm in the absence of preliminary relief. 3. The balance of equities tips in her favor. And 4. An injunction is in the public interest. Plaintiff's motion fails at every step. Okay, so the first argument, plaintiff has no likelihood of success on the merits. Plaintiff's unclean hands mandates denial of the motion. As a threshold matter, plaintiff's motion should be denied because she has come to this court in bad faith and with unclean hands after repeated attempts over an extended period of time to associate herself with Miss Swift and the album and to profit off their associated goodwill by infringing upon Miss Swift's intellectual property. The doctrine of unclean hands applies as a defense to alleged trademark infringement. Where a plaintiff, like Miss Flagg, deliberately attempts to create confusion surrounding trademark use, unclean hands is found and injunctive relief is denied. In Metro, the plaintiff, a publisher, alleged infringement of its Public Eye trademark against the defendant, another publisher distributing a tabloid section called Eye. After Metro learned of San Jose's use of Eye, Metro changed its use of Public Eye to feature Eye in a typeface similar to San Jose and continued to do so beyond the range of its normal prior use. Plaintiff's conduct was enough for the court to find unclean hands and deny injunctive relief, stating, even if Metro had shown a likelihood of confusion, it would not be entitled to equitable relief. Miss Flagg's conduct is far more egregious. She went beyond changing a typeface, instead using a nearly identical typeface, color palette, and design layout in her teaser, coupled with over 40 promotional social media posts using actual album logos, imagery, hashtags, audio, and lyrics. Plaintiff's posts do not just reference the album title, but specifically reference Miss Swift, her music, her albums, and the Eras Tour, attempting to associate her brand with them. Plaintiff's repeated references to Miss Swift and/or the album were intentionally designed to benefit plaintiff by causing association and/or confusion where none existed. Such conduct bars her from the relief she now seeks. Plaintiff seeks to impede defendant's First Amendment rights. Plaintiff claims also fail because defendant's expressive use of the life of a showgirl is protected by the First Amendment. When the allegedly infringing use of a trademark is in the title of an expressive work, the Ninth Circuit applies the Rogers test. Under Rogers, if If a work is expressive, a plaintiff cannot establish infringement without showing the title, 1, is either not artistically relevant to the underlying work, or 2, explicitly misleads as to the source or content of the work. This is because titles of expressive works implicate the First Amendment rights of freedom of speech, and consumers are less likely to mistake the use of someone else's mark in an expressive work for a sign of association, authorship, or endorsement. Songs and album titles are the core type of expressive First Amendment work that Rogers protects. Promotional efforts related to the expressive work are also protected by Rogers. First, the album title has clear artistic relevance to the underlying work, as it both describes the central theme of the album and shares its title with one of its songs, The Life of a Showgirl. Indeed, Miss Swift has explained that inspiration for the title came from her experiences while performing during the Eras tour, combining the physical exhaustion of grueling 3.5-hour performances with the creative stimulation of songwriting, literally living the life of a showgirl. Second, there is nothing misleading, explicitly or otherwise, about the album source. It is readily apparent that the album is associated with Miss Swift, as it depicts her instantly recognizable name and or likeness on the album and all related marketing and promotional materials. Because the First Amendment protects the expressive album title, the promotional goods associated therewith benefit too. In an almost identical case in December 2025, a sister court in this district denied a preliminary injunction where a plaintiff, Lost Surfboards, owner of a Mayhem trademark for surfboards in Class 28, sought to preclude musical artist Lady Gaga from using Mayhem as the title of her album and on related goods. Lost recognized and applied Jack Daniels and Punch Bowl, both cited by plaintiff, but denied injunctive relief, finding the album, including its title, was an expressive work. Lost also found that the promotional merchandise in connection with the Mayhem album was protected by Rogers because it applies not only to the title or body of an expressive work, but also to auxiliary revenue-generating promotional activities, including the sale or licensing of consumer goods. This holding is on all fours with the album and associated goods at issue here. Plaintiff claims Rogers is inapplicable. Plaintiff is wrong. As an initial matter, the mere filing of a trademark application does not transform the title of a musical work into a source identifier. Thus, at minimum, the album is protected here. Furthermore, just like in Lost, the use on merchandise such as clothing is a logical extension of the expressive work and also protected. Indeed, defendant's web store, the only place authorized merchandise is available for purchase, is organized by album name to group promotional merchandise associated with each of Miss Swift's albums and has a shop by album filter. At the forefront of that web store is Taylor Swift, denoting the source of the albums and the promotional merchandise, along with Taylor Swift, depicted as a registered trademark. Defendants do not use a TM symbol near use of the life of a showgirl. Because defendants' use of the life of a showgirl is expressive and otherwise satisfies the two-part Rogers test, the Lanham Act does not apply and plaintiff cannot succeed on her claims for a trademark infringement. There is no likelihood of confusion. Even if the Lanham Act likelihood of confusion analysis applies, it does not. Plaintiff utterly fails to meet her burden under that test. Plaintiff must demonstrate a likelihood of consumer confusion over the source of her goods or services. In a reverse confusion action like here, this requires evidence that an appreciable number of consumers believe or are likely to believe that defendants, rather than Miss Flagg, are the source of her cabaret and related services. This test is viewed through the lens of a reasonably prudent consumer in the marketplace. In practical terms, this means an appreciable number of consumers would have to believe plaintiff's cabaret performances were somehow associated, sponsored, or authorized by Miss Swift. No one can seriously contend this to be the case. In any event, courts applied the Sleekcraft factors to analyze the likelihood of confusion. 1. Strength of the mark. 2. Proximity of the goods. 3. Similarity of the marks. 4. Evidence of actual confusion. 5. Marketing channels used. 6. Degree of care likely to be exercised by the purchaser. 7. Defendant's intent in selecting the mark. And 8. Likelihood of expansion of the product lines. The first 3 Sleekcraft factors are particularly important in reverse confusion cases. When evaluating, the court must consider the factors taken together and in context. The Sleekcraft factors weigh against any likelihood of confusion. Plaintiff's mark is weak. In reverse confusion cases, the strength of the mark factor compares the commercial strength of a defendant's alleged trademark use with the conceptual strength of a plaintiff's trademark use. Without a conceptually strong mark, plaintiff will be unable to establish a likelihood of confusion, even if defendant's commercial strength is likely to overwhelm the plaintiff in the marketplace. First, plaintiff admits her mark is suggestive and therefore conceptually weak. Plaintiff is correct in that admission, as she has readily described her services as providing real-life confessions of a showgirl in a cabaret setting. This type of mark, which on its face suggests the very service provided, undercuts the potential for any purported confusion. Additionally, extensive third-party use of a trademark further weakens its strength. Here, third parties have widely used and or registered confessions of a showgirl and of a showgirl in connection with entertainment products, services for years prior to plaintiff's use, and have continued to do so after her registration, including, but not limited to, confessions of a goddess, confessions of a Vegas showgirl, portrait of a showgirl, and the last showgirl. Plaintiff cannot monopolize showgirl. Formulative marks in entertainment. Given the weaknesses of plaintiff's mark, she is unable to show likelihood of confusion. Lack of proximity of the goods and services. Differences in products or services negate reverse confusion, even when the products are superficially within the same category. This is particularly true in the entertainment field, where, as here, the nature of the entertainment is demonstrably different. Plaintiff attempts to broadly lump her cabaret show and defendant's musical album together as entertainment services. That comparison is absurd. Plaintiff's registered services focus around live stage performances that are limited to theatrical productions, namely her cabaret show, which take place at small limited venues. The life of a showgirl does not overlap with any of plaintiff's services. First, The Life of a Showgirl is a musical album, not a live theatrical cabaret show, and while Miss Swift has not performed album music as of this submission, historically her performances are musical concerts at sold-out stadiums with thousands of attendees, not at golf resorts or cabaret-style venues. I mean, what he's saying is right in that sense, in how he's trying to differentiate themselves. I just feel like has been a bit mean about it. Whether they are substantially different enough, though, like in terms of an umbrella where they are both entertainment services, will remain to be seen. But yes, Taylor Swift does not perform at golf resorts, so that is a difference. The significance of which is, to be determined. As for plaintiff's other alleged services, Miss Flagg has not posted any podcast episodes or produced a column or TV content in connection with her mark, and it is doubtful whether she is currently selling a book. Finally, as to consumer goods, plaintiff does not sell and never sold any apparel or merchandise, negating the assertion that defendant's promotional apparel or merchandise are proximate. Notably, despite repeatedly pointing to the USPTO's office action, plaintiff ignores that the USPTO found no issue with any of defendants' applied for goods outside of classes 9 and 41. The vast differences between the parties' respective goods and services weigh decidedly against an injunction. Dissimilarity of the marks. The alleged trademarks are not similar. When evaluating this factor, courts look at the sight, sound, and meaning of marks at issue. Courts do not consider trademarks in the abstract, even where, as here, a plaintiff has a standard character registration, but rather in light of the way the marks are encountered in the marketplace and the circumstances surrounding the purchase. Tellingly, the motion does not include any example of how plaintiff's mark appears to consumers. That is because defendant's use of the life of a showgirl is highly distinct from plaintiff's use. Specifically, they differ as to dominant terms, font, coloration, meaning, spacing, and total commercial impression. Where marks appear in the marketplace with dissimilar visual or contextual appearances, confusion is unlikely. Sight. Visually, confessions. Plaintiff's dominant highlighted term is not present in the album title, as plaintiff's own authority makes clear. The lead works in marks are their dominant position and are likely to make the greatest impression on consumers. Additionally, the color choices and imagery initially associated with plaintiff's mark are highly distinct from the album. Plaintiff's mark is customarily depicted with a red/yellow or yellow/pink color scheme and in connection with plaintiff's image and likeness. Defendants depict the life of a showgirl differently in terms of font, color, spacing, design elements, and imagery. Plaintiff does not address these marketplace differences, likely because where these types of attributes are different, no likelihood of confusion is found. Moreover, Miss Swift's likeness is almost always prominently displayed in conjunction with the life of a showgirl, further dispelling any likelihood of confusion. The unmistakable differences in how the terms are actually depicted to consumers also undercuts the relevance of the USPTO preliminary office action relied on so heavily by plaintiff. USPTO analysis generally is decided upon a comparison of the marks in the abstract, whereas courts assess the market as it actually exists. Thus, where office actions involve intent to use applications like here, courts afford them very little weight because they do not show marketplace conditions. Here, the court has the benefit of starkly contrasting marketplace evidence not available to the USPTO. Thus, any reliance on the USPTO's preliminary office action would be misplaced. Sound. Confessions of a Showgirl and the Life of a Showgirl sound different. When spoken, plaintiff's mark starts with a sharp C sound and contains a different number of syllables. To disregard these obvious differences, plaintiff relies on In Re National Data Corp for the premise that a similarity in cadence can support confusion. However, plaintiff admits that the marks at issue were cash management account and the cash management exchange. Where the dominant portions were identical, facts obviously not present here. Just because marks contain an overlapping term does not mean that there is a likelihood of confusion. Meaning. The meaning of Confessions of a Showgirl and the Life of a Showgirl also differ significantly. When evaluating meaning, courts look to dictionary definitions and root origins of the words. When a dictionary is consulted, something plaintiff did not do, Confessions is associated with 1. An acknowledgement of guilt, 2. A formal statement of religious beliefs, and or 3. Disclosure of one's sins. Yeah, But they can also refer to just like, you know, recanting past things like, here's my confessions of my life, it's not necessarily associated with sin or guilt or religious beliefs. Like, people do use it in a wider context, beyond potentially what the dictionary says. In contrast, life is associated with the physical and mental experiences that make up the existence of an individual, obviously a completely different meaning. The different implications of services purporting to share the confessions of a showgirl versus musical art relating to the life of a showgirl are readily apparent. Consumers are likely to exercise a high degree of care. Where a consumer exercises a high degree of care, confusion is unlikely. Music is intensely a matter of personal taste, and purchasing a concert ticket is not an impulse purchase. Here, plaintiff's cabaret services and the album are not impulse buys. It is widely known that Miss Swift's fan base is a dedicated and informed set of consumers. Their attention to detail is legendary when it comes to information about Miss Swift's albums or merchandise, with fans eagerly detecting Easter eggs and poring over Miss Swift's works in connection with numerology codes and word searches. There is no chance they would be confused between plaintiff's cabaret shows and Miss Swift's album and related promotional merchandise. Plaintiff provides no evidence to the contrary and merely declares that the degree of care is at its lowest for promotional merchandise purchased online. That is not the case. Putting aside that the album is available in physical stores, plaintiff's authority, issued in 2000, has long been supplanted in the Ninth Circuit with case law that more accurately reflects the internet-savvy buy-in public of today's world. It is undeniable that consumers today exercise a high degree of care when selecting expressive works or tickets for live entertainment, even more so when the work involves Miss Swift. There is no credible evidence of actual consumer confusion. Relevant confusion is that which affects purchasing decisions, not confusion generally. Importantly, a handful of examples of anecdotal confusion are insufficient to support a finding of confusion, as are isolated, unauthenticated web postings. At best, that is all plaintiff has. In reality, of the innumerable social posts related to the album and Miss Swift since its announcement, defendants are aware of no instances of actual consumer confusion between these brands, nor has plaintiff identified any. Plaintiff's services have contracted, not expanded. For this factor, courts ask whether the allegedly infringing mark is hindering the plaintiff's expansion plans. Mere speculation is not evidence of expansion. A strong possibility of expansion into competing markets must be shown. Plaintiff provides no evidence that she intends to expand her mark into merchandise, apparel, records, music concerts, or other goods and services. She failed to provide evidence that she even released a single podcast episode or video content in connection with her mark outside of social media. Rather, all evidence indicates that over the years, plaintiff's trademark use has contracted in scope. Plaintiff deleted an entire class of goods from her mark, is not currently selling her alleged book or writing her alleged column, and has not performed in months. There is simply nothing to support plaintiff's bold assertion of expansion. While plaintiff heavily relies on the application to show defendant's likely expansion, that is not enough. Even where a defendant has previously filed an intent to use application related to other goods or services, where a plaintiff fails to provide any concrete evidence that the defendant plans to use the alleged mark in connection with the sort of product that would compete with the plaintiff, this factor weighs against confusion. That is exactly the case here. The parties use different marketing channels. The 3 sentences plaintiff devotes to this factor fail to provide evidence of the consumer base for any of her alleged services or products, or that there is overlap in the parties' marketing channels. Advertising the existence of direct competition and retail distribution are considered when addressing whether the parties use similar marketing channels. Where the parties advertise or distribute their products differently, likelihood of confusion is diminished. While plaintiff claims to use YouTube to market her services, the most recent video on her channel is from 10 years ago. And while she claims to promote on television, the only evidence defendants can locate is from over a year and a half ago. With respect to the internet, plaintiff's performances appear to be promoted via her website, which does not allow consumers to currently purchase any cabaret tickets, books, etc. In contrast, defendants' merchandise is sold exclusively on www.store.taylorswift.com, immediately conveying via the domain name, website header, and merchandise, which prominently displays Miss Swift's name and likeness, that the source is Miss Swift, not plaintiff. The album is also sold in third-party retailers and streamed on music streaming platforms, 2 channels that plaintiff does not use. Of the prior shows listed on plaintiff's website, Miss Swift has never performed there. There is no meaningful overlap in marketing channels. Defendants have no intention to infringe. Infringement is not willful if the defendant reasonably thought that its proposed usage was not barred, and merely conducting a trademark search and discovering plaintiff's use is insufficient to demonstrate intent. Here, plaintiff failed to provide evidence that defendants intended to associate with her business or intended to push plaintiff out of the cabaret performance market. Plaintiff's broad references to TASRM's trademark portfolio have nothing to do with the instant matter and certainly nothing to do with defendant's intent in this instance. And as explained throughout, the USPTO proceeding for the application is ongoing and non-final. In any event, the very case plaintiff cites explains that an inference of bad faith does not arise from mere knowledge of a mark when the use is otherwise objectively fair, even in a case presenting reverse confusion. Given the dissimilarity and lack of proximity among other Sleekcraft factors, defendants clearly have a good faith belief that there is no infringement. There is no reason defendants could have or should have anticipated that Miss Flagg would claim to possess a monopoly over the descriptor of a showgirl, even in expressive works. Taken as a whole, the Sleekcraft factors favour defendants. There is no likelihood of confusion and the motion should be denied. Plaintiff has not shown any irreparable injury. Because plaintiff has failed to demonstrate a likelihood of success on the merits, no presumption of irreparable harm applies. However, even if the presumption applied, it is readily rebutted due to plaintiff's delay and the fact that any harm to plaintiff which defendants vigorously contest exists is readily compensable with money damages. Plaintiff's 8-month delay negates a finding of irreparable harm. A long delay before seeking a preliminary injunction implies a lack of urgency and irreparable harm, negating a need for preliminary injunctive relief. Here, plaintiff admits to knowing about the album in August 2025 when she consulted with counsel. Plaintiff then inexplicably waited a whole 8 months before filing the motion, all the while intentionally attempting to associate herself with Miss Swift and the album. This delay is longer than cases where allegations of irreparable harm were rejected at the preliminary injunction stage. Plaintiff's excuse for her unreasonable delay, allowing the USPTO examination process to run its course, is nonsensical. First, the non-final office action occurred in November 2025, 4 months before plaintiff's motion. And second, the USPTO examination is still ongoing. Ninth Circuit precedent is clear that other proceedings do not provide an excuse for delay. Just to kind of push back a little bit on that statement, though, yes, it is still ongoing in the sense that, it's not been finalized, but it's not being finalized because Taylor Swift's camp asked for it to be suspended while still continuing to, use the trademark. So it's a little bit disingenuous. Any purported harm is compensable, not irreparable. Economic injury alone does not support a finding of irreparable harm because such injury can be remedied by a damages award. Assuming plaintiff could show she was actually injured, she cannot. There is nothing to suggest that money damages would be an insufficient remedy. Specifically, the harm plaintiff claims loss of customers, goodwill, and or the ability to control her business reputation can all be remedied by money damages. Moreover, to satisfy Winter, plaintiff must show irreparable harm is likely, not a mere possibility. Plaintiff has utterly failed to do so, relying solely on unsubstantiated claims that consumers have come to associate her mark with someone else. Plaintiff's declaration is silent as to any of her alleged injuries, pecuniary or irreparable. That is because they do not exist. As such, it is unsurprising that the only evidence plaintiff points to, screenshots of Google searches run by plaintiff's counsel, are speculative at best and do not show actual harm and have previously been rejected as sufficient evidence of irreparable harm. Algorithmic results reflect consumer preference, not consumer confusion. There simply is no irreparable harm here. Denial of the motion is mandated. The balance of hardships weighs strongly against an injunction. In evaluating the balance of hardships factor, courts must consider the impact on both parties. Absent an injunction, plaintiff's business will remain unchanged. Defendants, on the other hand, would incur significant harm. Where a plaintiff like Miss Flagg has delayed seeking relief, the balance of hardship favours defendants. This recognises that a plaintiff should not be permitted to stand on the sidelines watching a defendant make significant investments in products and services only to belatedly attempt to stop the impact of those investments. Plaintiff seeks to do just that. She admits she was aware of the album in August 2025 and its release in October 2025. She admits she was aware of the August 2025 application and the November 2025 USPTO non-final office action. Yet she raised no alarm for months. Even worse, she actively tried to connect herself to the album / Miss Swift on social media using Miss Swift's intellectual property and littering posts with hashtags related to Miss Swift. Does this comport with Miss Flagg's claim now that the threat to her mark is existential? Of course not. While plaintiff said nothing, filed nothing, and centered her brand on Miss Swift's art, defendants spent millions of dollars releasing an album with an extensive global marketing and branding campaign, creating, manufacturing, and marketing accompanying merchandise and related goods. Were a preliminary injunction to issue, the status quo would be significantly altered and fundamental creative rights would be curtailed. Specifically, it would require defendants to remove all album and album-related products from the physical and digital marketplace, cancel sales, destroy goods, and most importantly, impose immeasurable harm to Miss Swift's own First Amendment rights. The hard costs of this loss of revenue and investment would likely total in the tens of millions of dollars just in the first 2 years. And this financial cost does not come close to that of stifling an artist's ability to create and share her work. It is impossible to put a price tag on that. Plaintiff's situation, on the other hand, would be unchanged. This is not a situation of self-inflicted harm, as plaintiff claims. As explained throughout, the USPTO non-final office action is just that, non-final and subject to rebuttal. Examination of the application is ongoing, and as described above, the non-final office action should not be afforded weight in this proceeding, nor does the fact that defendants have not yet toured in support of the release support an injunction. If anything, it counsels against one. Given these realities, it is not surprising that defendants have not identified a single case, and plaintiff cites none, imposing the significant preliminary relief involving an artist's music and related goods that plaintiff seeks here. The balance of hardships tips fully in defendant's favour. The public interest weighs against an injunction. If there is no likelihood of confusion among consumers, there is no public interest in granting the injunction. Where a movement like plaintiff has not made a clear showing that she is entitled to any preliminary relief, the public interest is against imposing injunctions. Here, for the reasons detailed above, there is simply no likelihood of confusion between plaintiff's cabaret show and defendant's album and associated goods, so the public interest weighs against an injunction. Further, where the impact of an injunction would significantly affect third parties, like here, the public interest is not served. At a minimum, if forced to cease sales and recall the album and its promotional materials, at least the following parties would be negatively and significantly affected: co-writers, producers, mixers, and other royalty-based musicians who contributed to the album, whose income in connection with the album and songs would cease. 2. Retailers, which would need to remove the album from hundreds of stores and online. And 3. Music streaming platforms, which would need to remove the album. The removal of music and related goods will also, of course, significantly impact millions who wish to listen to and/or purchase Miss Swift's music. Given the commercial success of the album, the impact of such removal cannot be overstated. Plaintiff fails to acknowledge the harm an injunction would inflict on these parties, and the public interest weighs strongly against the relief plaintiff seeks. Any bond must compensate defendants for a wrongful injunction. Because an injunction is unwarranted, the court need not reach the issue of the bond amount. However, should the court reach the issue, any bond must compensate defendants for damages sustained in the event of a wrongful injunction. As explained above, any injunction would cause defendants to suffer substantial losses. Should a bond be necessary, this court should hold a bond hearing to determine the appropriate amount. Plaintiff's attempt to skirt the bond requirement must be rejected. Conclusion. Plaintiff's motion for a preliminary injunction should be denied. Okay. I couldn't say that I can't deny that is, it's a good response as well. I'm really on the fence here. I think there were some parts of this was quite disingenuous and embellished, but they made some really good points too. I'm going to have to really think about this one actually, but I'm curious to know what you guys think. So let me know in the comments. It's a hard one. It's a hard one.